appeal Bahamasair Holdings Limited and Messier Dowty.
Yes.
Good morning, my lords.
Good morning to you.
My name is Crystal Roll. I appear with Mr. Wallace Roll on behalf of the appellant, Bahamasair Holdings Limited.
Yep.
Mr. Tim Marlin, along with Mr. Coy Akone, appear on behalf of the respondent, Messier Dowty.
Good. Thank you. Now, we've read all the papers, and we're as familiar as I think a lay court can be with the technical details, so you don't need to spend much time on those.
Well, my lord, I always find that it's useful to begin at a point where there's some consensus. So perhaps we should go to the statement of facts and issues,
Yep.
which is...
Well, we've read those very carefully.
Yes. And that is at page 1855 of the electronic bundle.
1855.
Yes, my lord.
Thank you.
And the internal numbering,
The internal numbering, my lord, would be
or paragraph?
paragraph 3,
Thank you.
which, my lord, is, by way of introduction, a reference to the event which we agree occurred on the 20th of April 2007, whereby there was a landing gear collapse in respect of one of the aircrafts of the appellant. If we look at paragraph 4, my lords, it is also an agreed fact that the landing gear collapsed as a result of a malfunctioning in what is called the shock strut. I find, my lord, that in a matter like this, where there was some technical evidence, it's good for me to just give a brief synopsis as to the technical aspects of the case.
Right.
So the landing gear, my lord, has an internal component that is referred to as the shock strut. Within the shock strut, there is a cylinder, which from a layman's standpoint, we can consider as being a tube of sorts. And within that tube, there are components that are the subject of this litigation. There is, first of all, what is called the piston.
Where's the best diagram of this?
The best diagram, I would say, would be within the expert reports that were tendered by the appellant.
Page number, or don't you have it? Doesn't matter if you don't.
Well, the thing is, my lady, I do intend to get to it,
Oh.
and I think that it would be helpful.
Okay.
I'm obliged. So I made reference to the piston. Attached to the piston is the upper bearing, which is one of the parts that will figure prominently in our presentation today. And attached to the upper bearing is a part called the damper ring. Now, a shock strut, damper
ring. Yeah.
Yes. And in the papers, my lord, you may also see it referred to as a rebound ring.
Yeah.
So the purpose of the shock strut is to provide shock absorption for the plane when it lands. And the way that that is achieved is from a combination of hydraulic fluid and nitrogen gas within that cylinder. Now, specifically, the specific role of the upper bearing and the dampering is the dampering has a number of holes that are referred to as metering holes. And what happens is that the hydraulic fluid travels through those holes. And it is that process that arrests the speed at which the piston moves within the cylinder. And it is that process that brings about the cushioning that is required to provide shock absorption. Now, the problem that was the pleaded defect in the litigation in the court below is that the shock strut experienced what is called loss of damping.
Sorry, what's called?
Loss of damping.
Yes.
And if you were to take the second component of that phrase, damping, it is quite simply the speed at which the piston is moving within the cylinder. So the speed is said to be damped by virtue of the control of hydraulic fluid through the metering holes, in the damper ring. So because there was this loss of damping, there was no shock absorption, and essentially the landing gear collapsed. So the question then became, what is it that causes loss of damping? And that is, again, an agreed fact as between the parties. That being, and I can take you to the paragraph, paragraph 19 of the Statements of Facts and Issues. It is a pretty technical thing, so there was no dispute there as to what resulted or what could result in loss of damping. And it is the absence of that dampering, a disengaged dampering, a broken dampering, or improper servicing of the landing gear. Now, the reason is pretty straightforward in the sense that because the hydraulic fluid goes through these metering holes, if there is any malfunction or absence of the dampering, then there's a problem, because the hydraulic fluid is then not going through the metering holes. If there is low oil volume or improper servicing, the problem is the same. Because the volume of oil is low within the cylinder and the dampering is at the top, the problem then is that the hydraulic fluid is not traveling through the metering holes and there's no damping of the movement of the piston within the cylinder, which ultimately results in a landing gear collapse. So the question for this litigation was, what was it that caused this particular landing gear to collapse? Our pleaded case, the appellant's pleaded case, was that there was a defective dampering and that ultimately it disengaged, it fragmented, and loss of damping resulted by reason of a disengaged and fragmented dampering.
It was never recovered, is that right?
It was never recovered, no. The case, though, that was put on by the appellant was that though the fragments of the dampering were not recovered, there were markings on the various components that indicated its presence prior to the collapse. And I'm going to get to that evidence. And so we had these, we would say, competing causes between the parties as to what ultimately caused the loss of damping and what ultimately caused the collapse. The respondent's pleaded case was initially, and I say initially because the evidence of the respondent was that there was no dampering. And the pleaded case was that the loss of damping resulted from improper servicing. What I think might be helpful is to go to the pleadings The statement of claim, my lord, is at page 80 of the electronic bundle.
Which bundle is that, please?
That would be volume 1. Page 80.
Yes?
And we're going to go to paragraph 15.
Sorry, page,
Pardon me? Page 82.
I've got the amended 82.
The statement of claim itself starts at page 80.
Not in ours.
I'm sorry, I'm having...
We've got, as page 80, we've got the second page of the amended defence, Mrs. Robb.
Correct.
Probably 64.
I'm afraid this is one of the problems with the case is that the hard copy bundle and the electronic bundle still do not marry up. So if you're working from the hard copy, the electronic...
Page 61.
Well, that should not happen.
It shouldn't.
No.
It's there.
And I mean, both parties are responsible for ensuring the synchronicity of the hard copy with the electronic bundle.
Sorry,
So you wanted the statement of claim, which page of it?
the statement of claim in the hard bundle is page 61.
Well, it's 63, yeah.
63.
No, it isn't.
Anyway, it's hard copy 65.
It should be tab
electronic
6.
bundle, 82. So let's get on then.
It's paragraph 14, did you say?
Should I refer to the electronic or the hard? Which
Both,
is,
please.
my apologies.
That's all right.
Which paragraph of the statement of claim?
So if we were going to, we're going to go to paragraph 15.
Thank you.
And that is under the caption, the cause for the landing gear collapse. And on to paragraph 16 is where I'm going to read from. And you see that this is what was the pleaded case as to the cause of the collapse in the court below. And it reads, the plaintiff will aver that the left main landing gear of the aircraft collapsed for the following reasons, namely, after the landing of the aircraft, the left main landing gear failed structurally. The left main landing gear failed structurally because of overextension of the shock strut piston, which allowed the torque links to go over center and rest on the piston, resulting in a loss of shock absorption. The piston overextended because there was a loss of internal rebound damping. The loss of internal rebound damping was caused by a damaged damper ring, which also resulted in damage to the upper bearing. We then say at paragraph 17 and 18, further, the plaintiff will aver that the damper ring and the upper bearing in the shock strut assembly of the left main landing gear of the aircraft were defective and or had latent defects and or were of insufficient hardness or durability to withstand the normal and or recommended usage and maintenance cycles which had been recommended by the defendant. In the premises, the damper ring and upper bearing of the left main landing gear of the aircraft sustained damage during normal usage, which ultimately caused the left main landing gear to collapse. So, my lords, that was the pleaded case of the appellant as it relates to the cause for the collapse and the cause for loss of damping. If we go now...
Just before you leave that,
yes.
I don't want to oversimplify, and if I am doing, tell me. Looking at 16, 1, 2, 3 and 4,
Yes.
am I right that 4 was the only point at issue?
Pardon me?
Am I right that 4 was the only point in issue?
Correct.
Thank you.
Yes. 1 through 3 were agreed, and 4 was disputed.
Right.
Yes.
Yes. And if we then go to the amended defense, which is tab 7 in the paper bundle, page 96 in the electronic bundle. And we're going to go specifically, my lords, to paragraph 10. Shall I proceed?
Yes, yes, indeed, yes.
Yes.
We're just going to try to eliminate the exterior noise.
I'm obliged. So, my lords, at paragraph 10, what we see is that there is a plea of contributory negligence being advanced by the respondent. And there are a number of specific elements of this plea of contributory negligence, beginning at paragraph 10, Roman numeral 1. The first of which essentially is an allegation of improper maintenance. The plaintiff and or its agents and or servants failed to maintain and or repair the aircraft prior to the incident, which allowed the landing gear to be exposed to a possible and eventual failure and collapse. The second was that the plaintiff and or its agents or servants failed, refused, or neglected to properly maintain the appropriate proficiency levels and documentation for the qualifications of its maintenance personnel. The plaintiff, through its agents and or servants, failed, refused, or neglected to properly service and maintain adequate and proper hydraulic fluid levels of the landing gear, and that would be the improper servicing assertion. The plaintiff, through its agents and or servants, failed to carry out the replacement of a shock strut cylinder on the aircraft in accordance with the Aircraft Component Maintenance Manual and industry standards. Also by failing, refusing, or neglecting to check and cross-check the work that was supposedly carried out. The plaintiff and or its servants and or
Well, I
its
think we can read all of it.
Yes.
Thank you very much.
Yes, my lords. So essentially, my lords, you had a plea of contributory negligence that raised a number of issues: improper maintenance, insufficient hydraulic fluid, a failure on the part of an alleged failure on the part of the appellants to carry out various checks and to respond appropriately to various issues with the aircraft. And, my lords, upon receipt of just to give the court a global view as to the pleading process, there was a reply,
Yes.
which is in the next tab.
Right.
And by way of summary, the apply, of course, joined issue with the issues raised in the defendant's defense, but specifically as it relates to the pleas of contributory negligence. The reply would be at page 82 of the
I think
paper
it
bundle.
might be 84, but in any event, you, as you say, joined issue with the plea of contributory negligence.
Yes, and as it relates to certain specific elements of the pleas of contributory negligence, i.e. Tires being blown, vibrations, failure to maintain appropriate records, failure to have or maintain credentials for the personnel that were working on the plane. Specifically, the issue of causation was pleaded as it relates to those elements of the contributory negligence plea.
Right.
So now, my lords, the reason I go through the pleadings is because the learned justice in the court below, Chief Justice, dealt specifically with, one, the allegations in the statement of claim as to the cause of the collapse, and two, the individual pleas of contributory negligence that were advanced by the respondents in the court below. And you would note that those pleas together really give you an idea or yield the reason for the ultimate cause of the collapse.
Yeah.
So if we can go to the judgment, which is in volume 1, tab 12. Paragraph 36.
Yes?
You see that at paragraph 36, this is where the learned justice starts to deal with the plea of negligence and contributory negligence advanced by the respondent as against the appellant. At paragraph 36, he says, the defendant's case is that even if the modified bearing and ring were installed, this accident happened because of poor maintenance by the plaintiff. In the closing submissions, on the defendant's behalf, it was submitted that the collapse of the main landing gear was not as a result of any negligence on their part. The defendant alleged that the plaintiff and its agents failed to properly maintain and or repair the aircraft, and that this was the sole proximate cause of the accident. So in the paragraphs following, my lords, you see that the learned Chief Justice addressed each and every allegation of contributory negligence and rejected each and every one and provided his basis for so rejecting them.
Rejection of a plea of contributory negligence doesn't establish negligence on the part of the defendant.
No. There is a specific purpose for making that point as I go on in my submissions.
Right.
Certainly there is an obligation on the plaintiff/appellant in this instance to make good on its plea that the damper ring was in fact installed and that it fragmented and broke during the course of normal operation.
Well, did the Chief Justice articulate the requirement that the plaintiff establish its case on the balance of probabilities?
Did he expressly say that?
Yes.
Well, what he did was he acknowledged the obligation of the plaintiff/appellant to, one, plead and prove its case.
Where
And secondly,
where did he do that, please?
if we go to the beginning when he deals with the plaintiff's case,
Try 29.
yes. He sets out the plaintiff's case at paragraph 26 in accordance with his pleadings.
Yes.
And then on at 27, he makes note of the admissions that were made by Messier, the respondent, in relation to what had been pleaded. Are you with me, Milos?
Yes, yes, indeed.
Right. And if I go back to paragraph 26, you see where he speaks about what the plaintiff has asserted and what they must establish. The plaintiff's case is that the overextension and collapse was caused by a defective upper bearing and dampering. Those parts were not sufficiently robust to withstand the period of usage recommended by Messier.
Yeah, well, we can read that, thank you. You don't need to read it, though. Well, thank you.
I'm obliged, my lords. But he said,
Does he at any point specifically say that the plaintiff must establish to the requisite standard the case that it had pleaded?
I do not believe, my lord, that the learned Chief Justice actually set out the burden that was placed on the plaintiff to adduce evidence to the requisite standard. But what he did do, my lord, he went through the evidence that was adduced. And by the time he got to the end of his judgment, he indicated that he was satisfied that the plaintiff had proven its case as it had pleaded it.
Right.
And, Lord, perhaps what I should do, because I've taken you, my lords, to the case of the appellant on the cause for the collapse. And if we were to backtrack a bit and point out that essentially the appeal that went to the Court of Appeal was an appeal of those findings that the learned Chief Justice made as to the cause of the, well, not the cause of the collapse, but that the parts were faulty. Inadequate is the verbiage that the learned Chief Justice utilized. And the Court of Appeal made a determination that those findings ought to be set aside because the learned Chief Justice's findings on those particular issues were both unreasonable and unsupported by the evidence. So what I am going to endeavor to do, my lord, is to demonstrate, one, that the Court of Appeal erred in that determination, that being that there was no evidence to support the findings that were made by the learned Chief Justice, and two, that his determination was unreasonable in the circumstances. And in so doing, I think the starting point should rightly be the determination as to inadequacy. That is essentially an acceptance on the learned Chief Justice's part as to the pleaded case of the appellant on the cause for the collapse. He accepted the pleaded case of inadequacy, and he also accepted that it was that inadequacy which manifested itself in a fragmentation and dislodgement of the dampering, and ultimately the collapse. And so, my lords, given, as his lordship has pointed out, it is a technical issue, the appellant in the lower court adduced expert evidence. And there were two expert witnesses. There was first Mr. David Hall.
Yes.
And there was also Mr. Aaron Jones.
They're called by the plaintiffs, are they?
Yes, they were, both of them.
And then there's Mr. Langston, is they're called for the defendant?
Mr. Langston was called by the defendant, yes.
Yeah.
So there were three expert witnesses in total. I should point out, though, that Mr. Langston's evidence was somewhat different from that of the plaintiff's experts.
That's not altogether surprising.
Well, not only difference in opinion, difference in substance.
Yes, I see. Right.
In the sense that the plaintiff's evidence was geared towards establishing the inadequacy of the components, the presence of the dampering, contrary to the assertion of the respondent, and the fact that it fragmented and dislodged during the normal usage. Mr. Langston, on the other hand, was focused predominantly on the assertion of improper maintenance.
Yes.
Did not condescend at all on the adequacy or inadequacy of the parts in question.
Is it common ground that the judge was right at 39 to say that the suggestion that there wasn't any dampering there at all didn't figure in the trial in the end.
That is correct.
Thank you very much. That's a help.
That is correct.
So that does leave us, does it, with either, as you, or at least you would say, the first question was the was there a breach of duty in failing to alert the owners to the fact that the kit had been redesigned?
Yes, and the reason for the redesign.
Quite.
The problems that
And
have been
in
experienced.
any event, was the cause failure of maintenance?
Pardon me?
Was the cause failure of maintenance?
Yes.
I see.
And, my lords, I take the point of his lordship pointing out that the ultimate abandonment of the lack of dampering pleading assertion is common ground. Would his lordship want me to go to the evidence on improper servicing?
Well, it's a matter for you.
Only because we were on that.
Yeah, well, don't let us interrupt your train.
I think it might be helpful, given that that was the pleaded case of the respondent, that actually was a potential cause of collapse of the various assertions that had been made. That is the one that really fell within the four causes or potential causes of collapse.
Yeah, but before you get to that, you've got to demonstrate, haven't you, that they did something wrong.
I do.
What is it that you say they did wrong?
Well, first of all,
The judge found that the failure was, that what they did wrong was not notifying operators of the planes that the leg had been redesigned.
well, not so much only that it had been redesigned, specifically that there was a problem,
Yeah,
that there was an inadequacy, that they were aware of
right.
and never brought to the attention of operators.
Yeah.
Now, the redesign and notification of the redesign in and of itself is not necessarily a significant issue. But given that that redesign, we say, and the evidence bears out, was solely as a result of an operational experience of problems and issues with the part, then clearly we say there was an obligation on the respondent to have notified the operators of that. So perhaps then I should go, as I had intended to do, to the issue of inadequacy. Firstly, the report of Aaron Jones.
This is summarised, isn't it, at part 6 of
Yes.
your case?
Well, starting, yes, at page 11 of the written case for the appellant. The expert reports are in volume 4. Aaron Jones is at tab 49.
That's page 479 or 509 in the electronic.
Correct.
Yes?
And it is 509, my lords, in the electronic.
Yep.
So it would be useful to go to the conclusions, which are 495 in the hard bundle and 525 in the electronic.
Internal page number?
495.
Printed page number?
Printed, 17.
17. Thank you.
Yes?
So if you look at the conclusions at internal paragraph 5, subcaption conclusions and opinions, see starting at subparagraph 1, Mr. Jones opines, the evidence and my analysis of the subject and exemplar landing gear components indicate that the dampering was installed on the subject left main landing gear when the strut was replaced in May of 2006. The evidence in my analysis also indicate that the dampering fractured and fragmented sometime after the strut cylinder was replaced in May of 2006. This is evident in the damage to the strut cylinder, seal carrier, and upper bearing. I'm going to stop there, my lords, because you will see, if you, in the preceding pages, there are a number of photographs
Yes.
which demonstrate, in Mr. Jones's opinion, markings demonstrative of the presence of the dampering.
Well, you needn't trouble about that because we've just been told it's agreed it was there.
Yes, yes, I'm obliged. Paragraph 3, the design and materials of the original upper bearing were inadequate and lacked sufficient robustness for the extension stop application and the dampering support application. The lack of robustness resulted in damage and fracture of the upper bearing and the fracture and fragmentation of the dampering. The redesigned upper bearing provides significantly more resistance to cracking and fracture of the bearing when the bearing contacts the seal carrier and stops upon strut extension. This is directly due to the geometric and material changes to the upper bearing. The redesigned upper bearing and damper ring significantly decreased the likelihood of the damper ring separating and/or fracturing from the retaining groove on the upper bearing. The accident would have been avoided had the redesigned upper bearing and damper ring been applicable to the subject aircraft at the time the strut was replaced. Now, the conclusions that Mr. Jones had included in his report were elaborated on during the course of his evidence. He gave evidence in chief as well as cross-examination. And as I point out in part 6 of the written case, he identified what he concluded was the initiating event of this process of fragmentation. And the initiating event, in his opinion, as well as in the opinion of our expert David Hall, was the tendency for there to be fatigue fractures at the base of the lugs. And if you still have the report open, if you look at page 16, which is opposite to the conclusions, you see that there are two diagrams of the upper bearing.
Yeah.
The top diagram is the new version. The bottom diagram is the old version, which was in the aircraft at the time of the collapse. There is an arrow that points to what is called the lugs, and it was common ground between the witnesses, that is the appellant's expert witnesses as well as Mr. Fisher, who was the respondent's witness of fact, that the purpose of those lugs was to hold the damper ring in place. It was the evidence, the expert evidence of both Mr. Hall and Mr. Jones, that his analysis and experience demonstrated fatigue cracks, or fatigue fractures at the base of those lugs. And ultimately, over time, the lugs would fracture to the point of literally dropping off, and that would allow the damper ring to fragment, well, to become dislodged and to ultimately fragment. Now, that is a position, my lord, that was repeated by the expert David Hall in his conclusions.
Before you go to that, can I just ask you whether it was suggested that a lack of hydraulic fluid would dispose the lugs to fracture?
Well, not specifically in that way. I think what was suggested to the witnesses was that a lack of hydraulic fluid would ultimately cause this damage, and that there was no damage or potential damage in the isolation, in the absence of improper servicing.
So did Mr. Jones deal with the question of whether there was any evidence of lack of hydraulic fluid, or what he thought about that aspect of things before he gave his report? Well,
what he said in the course of his evidence was that the question was specifically put to him what, if any, impact it would have, that is the absence or improper servicing on the process that he described, the fatigue fractures. And he said that the absence of hydraulic fluid would accelerate the process of deterioration. But to address Her Ladyship's specific point as to whether or not you can have this process of fragmentation, even with proper servicing, that is an issue that was specifically addressed. One, by the Air and Terror report, and to describe what that was an incident that occurred in 1996. And the report would be DS 650, and that report demonstrated that even where there was the approximate amount of hydraulic fluid, and the only reason why the word approximate is used is because it is normal for there to be some seepage. But they found in that instance that even where there was proper servicing, you had the lugs being broken off of the upper bearing, and you had fragmented damper rings. Now, as a follow-up to that issue, that question was specifically put by myself to Mr. Fisher.
My lady's question, the relevant passage to Mr. Jones's evidence is at 15 tab 54, page 860 to 862 in the hard copy, page 894 to, I assume, 896 in the electronic.
Sorry, in the hard copy it's...
It's 860 behind
Thank you.
tab 54. That's where he's asked about whether he considered this. He gives his reasons as to why he didn't see fit to mention it in his report.
Yes?
Yes. I was in response, my lady, I was pointing out that that is a question that was specifically put to Mr. Fisher. The fact that even in circumstances, well, the fact that the Air Ontario matter demonstrated to the respondent that you were having or they were experiencing damage to these components, even in circumstances where the gear was properly serviced.
And you say Fisher agreed with that, yeah?
He agreed with that contention, he did.
Okay. Can I just be sure that I'm not barking up the wrong tree? I've still got the diagram open in Mr. Jones's report, hard copy 494. Does the damper ring, as it were, sit under the lugs?
Yes.
And so by contrast, the new design, it's not held in place by 1, 2, 3, 4, 5, 6 lugs, but by a collar that goes all the way around.
Correct.
Okay.
Correct. And the evidence was that redesign was for the purpose of providing better support for the dampering, which they saw was dislodging. Yes. And of course, there was a material change as well from aluminum to steel.
Yes.
So in addition to, I was going to move on to the similar conclusions that were reached by Mr. Hall.
Can you just help us about whether Mr. Hall and Mr. Jones had, as it were, a different remit from you, Mrs. Roll? They both come from Sugar Grove. They both give their reports within 24 hours of each other. Is there some link between each other? And what was the different subject matter of their reports?
Well, the subject matter of Mr. Jones, first of all, given that his area of expertise is a little more specialized as a materials expert, a metallurgist, his was more so to examine material deficiencies. And he is also a fatigue fracture expert. And you find then that his report focuses to a larger extent on the specific nature of the material changes, between the old and the new bearing. And there is a significantly higher technical element, if I were to put it that way, from a metal standpoint. Mr. Hall, on the other hand, whereas he also specializes in failure analysis, his main, I would say, purpose, one, was to demonstrate the presence of the dampering, because of course at the time when the reports were being prepared.
Very well, thank you.
Yes. As to timing, my lord, it just so happens that the reports, by virtue of the case management order, were due at the same point.
Very well, thank you.
Yes. So Mr. Hall's report is in the tab just prior to Mr. Jones's. So that would be tab 48. .445 in the electronic bundle. His conclusions are at 471, internal numbering, page 55. The operative paragraphs, my lord, would be 6 paragraphs starting this ongoing wear. This ongoing wear occurring internally to the main landing gear shock struts and unknown to Bahamasair personnel was a result of a design deficiency that allowed the dampering and upper bearing as a unit to fail to operate in the manner that Messier Dowty intended, designed, and expected. This failure included both operational performance and component cycle limit aspects. He goes on the technologically feasible, preventative, and repetitive procedure previously mentioned could have been as simple as requiring the operator to perform a simple external measurement of the maximum strut extension length with the gear in the fully extended position. This distance is indicative of the internal deformation that has occurred between the bottom of the upper bearing and the top of the seal carrier. I'll stop there, my lords, because he's going into not so much the deficiency itself, but into what he has opined would be a preventative step that Messier could have instructed the operators to take to detect such internal damage. So the point then, my lord, is from an expert evidence standpoint, both of the witnesses, expert witnesses for the appellants, gave evidence both in their reports as well as in chief of the nature of this defect and its inadequacy. And ultimately, both of them concluded that the resultant dislodgement and fragmentation of the dampering is what caused this landing gear to collapse. So, my lords, I think it's also important on the issue of inadequacy to take the court to the evidence of Mr. Fisher. Mr. Fisher was witness of fact, but given his position as product support manager, he did have significant knowledge both as to the parts in question and we say also as to the existence and nature of the inadequacy. And he was extensively cross-examined. I'll find Mr. Fisher's evidence. Firstly, page 910 of the electronic bundle.
Which volume? Which tab?
It's going to start at page
876.
Thank you.
Sorry,
876 of the hard copy,
Yes, and 910 of the
910
electronic.
of the electronic.
I'm sorry, which bundle are we in?
It's going to be volume 5.
Volume 5? Thank you. Page.
Moment. I'll pull up the page.
It's 876.
You.
Yeah, for Fisher. So in the electronic bundle, it starts at 898, but I'm going to page 910.
Yeah.
I'm very sorry. I'm having difficulty hearing you, Mrs. Rowe. I'm
Apologies.
very sorry. It's my, I'm sure
In
it's
the
my fault.
electronic bundle,
No,
Mr. Fisher's,
No, I think, my
we're on
lord,
I'm on page 876 of volume 5.
876. Now, what do you want to look at here?
so at internal numbering 37 of the transcript,
Yes.
line 5. This is, first of all, Mr. Fisher's acknowledgement as to the role of the fragmenting lugs.
In the Air Ontario
Yes.
crash, which is 1996, is that right?
1996, yes. That is the issue that I'm referring him to when I pose the question. Switching back to the Air Ontario matter, isn't it true that a part of the result of your Air Ontario investigation was that the absence of the lugs contributed to the freeing or dislodgement of that dampering? And he agreed. He says, correct.
So it was the absence of the lugs.
Yes. Remember now, the expert evidence of the appellants was that the initiating event was fractures at the base of those lugs, which over time would ultimately break off.
So you don't mean that they hadn't been fitted, they're
No,
just broken
no.
off.
They just broke off.
Yeah.
Yeah.
And the breaking off then resulted in the dampering
Yeah.
dislodging.
Right.
And ultimately, the question was again put to Mr. Fisher at page 940. And I will give you the paper numbering.
Which is the electronic number?
The electronic number is 940,
940.
yes.
The
And
hard,
the paper bundle is 906.
06,
906, my apologies.
06, yeah.
Yes.
And we are at line 8. And to put this line of questioning in context, this is now a re-examination. And during the course of cross-examination, Mr. Fisher had sought to limit the cause of the dislodgement and fragmentation of the dampering to an excessive wear on the cylinder. And the question that I then put to him is again along the lines of the role of the breaking off of the lugs. And I say to him, what role, you said, the broken dampering or the dislodged dampering, given that we accept that the reason for the loss of damping, what role would you say that played? And the court inquires, in the case of Air Ontario, and I said, yes, Air Ontario. He says, in the Air Ontario case, where there was excessive wear to the bore, the rebound ring became dislodged as it was able to move between the upper bearing and the cylinder, and as it became dislodged, followed by loss of, and that should be damping. I said, and of course, this dislodgement is also allowed by reason of the fact that the lugs were broken on the upper bearing, correct? And he says, that does occur, yes. So you have Mr. Fisher on 2 occasions acknowledging that you have dislodgement and fragmentation of the dampering, by reason of the breaking off of these lugs, consistent with what the expert witnesses had said. So now, if we go back in Fisher's testimony to page 923, and what I'm endeavoring to show it by reference to page 923, you will recall, my lords, that during the course of the trial, there was evidence of a fleet-wide inspection that was carried out within the appellant's fleet-wide inspection carried out, not only of the subject landing gear and the subject aircraft, but also other landing gear within the fleet. And it was found, firstly, in relation to the subject landing gear, the subject aircraft, that the right landing gear had similar damage, and in relation to the sister aircraft, that the right landing gear of that aircraft also had similar damage, that being the broken off lugs and the fragmented damper ring. And again, I put the question to Mr. Fisher in the context of air and tear.
Which line is that, please?
It's going to be page 923.
Yes. Just having a little difficulty finding the line.
923 electronic, 889
Yeah.
paper.
Sorry, 889.
Yes, paper.
Yeah.
And line 8. And what's happening here is I'm showing him the parts from the other gear, other than the subject gear. So we go to line 12.
Right.
What I'm going to show you firstly is the upper bearing from the right main landing gear of
I'm
the
sorry,
subject aircraft.
I'm awfully sorry, this is my fault. 898, line 12.
898 paper, line 12.
I think it's 899.
889.
899.
Thank you.
Are you sure?
Yes, it's
889.
889.
889.
Yeah.
Yes,
889.
Line 12.
889.
Yeah.
889, line 12.
line 12. And 923 electronic.
Cut off anyway.
Yes.
912, and I say, what I'm going to show you firstly is the upper bearing from the right main landing gear of the subject aircraft.
Now,
I
that's
imagine
the one,
you've seen
that's
this
the
before.
one that didn't collapse, is that
That's
right?
the one that didn't collapse, same
Okay.
aircraft.
Yeah, yeah.
Yes. And showing it to him, he says he's seen it. Line 21, I say to him, and this is pretty consistent with what you would have found in the Air Ontario situation. He says, correct. I say, again, the right main landing gear of the subject aircraft, we have the damper ring. Have you seen this damper ring? He says, yes. I say, and I guess you can tell that it's broken by virtue of the fact that it's in a bottle holding the pieces together. And I say, again, this is somewhat similar to what you would have seen in the Air Ontario scenario. He says, yes. In terms of the damper ring broken and a number of pieces, he said, yes. The question then was put to him. Having regard to what we have seen happen in the Air Ontario with there being approximately hydraulic fluid, if you were to look at a scenario with the right main landing gear of the same aircraft where you have the lugs off and a broken dampering, am I correct in presuming that, and that should be damping in that right main landing gear, was compromised when that was in operation? He says yes. Am I also correct in presuming that at some point after the repeated contact between the upper bearing and the sealed carrier at the back, the damage would likely get to such an extent that we are going to have an overextension of the shock strut? And he agreed, yes. Now, in the lines that follow, we went through the same process with the right gear from the sister aircraft, and he agreed, again, that the damage of the lugs being missing and the fragmented damper ring were entirely consistent with Air Ontario, and that also, as it related to that right gear, we were also looking at compromised damping and ultimately collapse of that landing gear. So that goes over onto the over to the next page. So ultimately, my lords, after having had Fisher agree, essentially, with the same mode of failure that the experts agreed, opined as being the cause of this dislodgement and fragmentation, the questions were then put to Mr. Fisher, both as to the reason for the modification, number one, and as to their knowledge of this problem. If we go back again to page 919 of the transcript, this is in Fisher's testimony still.
Paper number?
Page 919, and it would be 885 on the paper.
Thank you.
885.
Yes.
Yes.
So we're going specifically to line 8. And this is the question that I put to Mr. Fisher. I am dealing specifically now with the reason for those modifications. And my suggestion to you now is, having encountered specifically the Ontario scenario, and recognizing that even with sufficient hydraulic fluid, you are getting an overextension situation as a result of the damage to the upper bearing and the damage to the damper ring. You modified those parts with a view to providing better support for the damper ring. Is that correct? Mr. Fisher says correct. So, despite what the documents had said as to the reason for the change and what he had said in his witness statement, which painted the reason for the change as being just an attempt to improve on the product, on cross-examination he acknowledged that from the respondent's standpoint, having regard to what they had seen in the Air Ontario matter back in 1996, where there was sufficient hydraulic fluid, and so this somewhat addresses Her Ladyship's question as well.
Well, if you carry on, what he's saying is an improvement to an already proven design.
Yes,
he's
that
not
is
accepting it's a fault.
Well, that is exactly what he had said in his witness statement. So if we go beyond that, he's repeating what he said in his witness statement. So now if we go over to page internal numbering 47, line 3.
Sorry, page.
So it would be electronic 920, hard 886.
886, line.
Line 3.
Thank you.
To put this piece of evidence in context, after the concession that he made to me, he then attempted to revert to what he had said in his witness statement, that being that it was only to improve on an already proven design.
Sorry, that it was only?
The change from the old to the new component
Was?
after acknowledging that it was done as a result of a recognition of a problem. He then attempted to revert to his original statement that he had made in his witness statement, that being that the change was solely to improve on an already proven design. So then the learned Chief Justice himself then questions him on the issue. And he says, the reason you had to improve on it was because you found, as a result of those instances, that there was a problem, that it didn't do what you wanted it to do. I mean, that's what I read from the Air Ontario report. As a result of that, these were the production changes that you undertook as a result of what you found. And Mr. Fisher said, yes, my lord. So, in so doing, again, his lordship put the position to him quite clearly and unequivocally that you found that there was a problem. And as a result of what you found, the modification took place. And Mr. Fisher conceded, in response to his lordship's question, that that was the reason for the modification. And so, my lords, from an evidentiary standpoint, as it relates to inadequacy, you then have not only what the appellant's expert witnesses have said, both by way of report and on oath, but you also have these concessions from the respondent's witness of fact, both as to the problems encountered with the part, both as to the inadequacy, and as to the reason for the modification. In the context, Lords, of the respondent's knowledge of there being a problem, in addition to Mr. Fisher's oral acknowledgement, you then had documentary evidence. And I will now refer the board to hard copy volume 3. Electronic bundle, page 296.
Is this tab 27 the report on Air Ontario?
It's going to be in the tab 34, sorry.
Thank you.
So did you say 34?
34 in the tab 34 in the hard bundle,
So that's 271.
and 296 in the electronic.
Electronic, I see, yes, thank you.
Right.
What you are looking at, my lords, shall I?
Yes, come on.
What you are looking at, my lords, is it's an internal document called an engineering order. And this document is a document of the respondents that relates to the change from the old dampering. And if you go over to the following page, tab 35, the change from the old to the new upper bearing. So at 35, you have the dampering. At 36, you have, 34 and 35, the dampering and upper bearing respectively. Same document, but relating to the two parts. At the bottom, there is a section called Product Support Information, Service Effectivity. And you see there in this document, as it relates to the change, it indicates that you have service action being required, you have service bulletins being required, and you have retrofit being required. Now, during the course of the evidence, and it's the same as it relates to the upper bearing, again, the determination by the respondent that these things were required, both service action, service bulletin, and retrofit. Mr. Fisher, during the course of his evidence, indicated that retrofit simply means the replacement of an old part with a new part. And so a determination had been made by the respondent in 1997, that being the date of that document, that this is what was required as it relates from the change from the old dampering, the old upper bearing, to the new dampering and the new upper bearing. The evidence, of course, was that despite what is provided for in these documents, that never occurred.
Yes.
If we go to Mr. Fisher's witness statement, and that is going to be in tab 4.
Tab 4.
Volume 4, my apologies. In the electronic bundle, it will be page 442. In the HAD bundle, it's tab 47, and we're going to go to Mr. Fisher's internal paragraph 92.
Yes?
Now, Mr. Fisher is describing the nature of the relationship that exists between the manufacturer and the operator. And he says, starting at, I'll go back to 91, the design of the main landing gear for the DHC-8 has been essentially unchanged since the initial design in the early 1980s, in part because of the highly regulated nature of the aviation industry and also as good business practice. Manufacturers of aircraft and their major components have a unique ongoing dialogue with the operators of their aircraft and parts. At all times, the manufacturer of an airline-level aircraft knows, for example, who is operating every aircraft it manufactured and has the ability to communicate with this operator. This dialogue helps the manufacturers to understand trends of the aircraft and parts as they are used, to modify maintenance practices, and to offer alternative parts based upon operational experience. He then, at paragraph 94, explains the various devices open to manufacturers to affect this communication and this dialogue that he's described exists. And of relevance would be subparagraph C, 94C, where he speaks of a service bulletin. And he says, a service bulletin and its more urgent counterpart, the alert service bulletin, are used by manufacturers to instruct operators to take certain action with respect to a particular aircraft and component. These actions often include inspections, changes in inspection intervals, and the introduction of more robust parts. And then he goes on to speak about what the regulatory body would do. In this instance, the regulatory body being Transport Canada, who may issue an airworthiness directive. But as it relates to the manufacturer and the service bulletin, the evidence was that in circumstances where the manufacturer, by virtue of operational experiences, has become aware of any concerns, any operational difficulties with components, or has resolved that there has to be retrofit, as is used in the respondent's documents, or the introduction of a more robust part, any of these eventualities, the service bulletin was the mechanism by which they would notify operators. The evidence, though, my lords, was that at no time, despite what was stated and the intention that was given, not only in the engineering orders, but also in the DS 650 report itself, no service bulletin was ever issued as it relates to the problems encountered with the damage to the upper bearing, the fragmentation of the dampering, and the reason for the introduction of the new parts.
Wasn't there, however, an all-operator memo disseminated in 1998, which actually wasn't directly referable to your aircraft, but had a relevant paragraph? Do you know what I'm talking about?
I know what you're referring to, my lord. You're referring to AOM 518.
Which came from Bombardier.
It came from Bombardier, not from Messier Dowty. Correct. And it was the evidence that that AOM was in no way applicable to this aircraft. And the paragraph, I think his lordship is referring to the paragraph that was lifted and recited in the Court of Appeals.
Yes.
That particular paragraph, and there is a point where I will take his lordship to it.
Very well.
That is speaking specifically to directives being given to the operator on how to deal with the removal of the pin from the upper bearing, which had no bearing whatsoever to the subject upper bearing. So there was nothing instructive in that AOM at all.
But we'll come to that paragraph in due course.
We will.
But we've got it here at 96A on the statement we're just looking at.
The witness statement, yes. Fisher did say that it had no relevance to
Yeah,
the subject
he did.
aircraft, correct.
Did this particular strut have a pin?
No. No.
That's what I thought. Thank you.
And that's one of the points that is going to be particularly germane to our case. The fact is, it's a completely different upper bearing. And so
So AOM 518, that particular paragraph in AOM 518 was relating to a pin which was not in this model at all.
Which was not in the subject aircraft, correct. And you'll find that that is a common thread, because a lot of the others dealt with that same issue, which clearly was a very perplexing issue as it relates to that particular upper bearing, not the subject of the litigation. So I think
You
it is
say no service bulletin following the Air Ontario inquiry and the orders which we've been looking at. There are references to other service bulletins, and I couldn't quite see what dates they bore or the extent to which they were relevant.
Well, it's probably an opportune time to go through them. There is Service Bulletin 83282.
Quite.
And I think it's helpful to go to that.
Thank you.
That is at page 323 of the electronic bundle. It will also be in volume 3. Tab 38 of the paper bundle. So, my lords, for the paper bundle, that's volume 3, tab 38. And for the electronic, it's page 323.
Yes.
Now, this is a perfect example of the manufacturer using this tool to communicate a number of things to the operator. Bearing in mind, again, that this is not applicable to the subject aircraft. It deals specifically with the upper bearing that has that pin to backtrack, the problem that they found in the course of operation was that that pin was preventing the upper bearing from turning as it ought to turn. And as a result, there was excessive wear of the cylinder bore being caused precisely by that pin. So you have this service bulletin being issued by Messier to deal specifically with that issue. Now, ironically, it was also issued in 1998, which is when one would have expected a similar service bulletin to have been issued subsequent to the 1997 engineering orders, which indicated that one would be forthcoming.
Yes.
But if you look briefly through, you look at the reasoning, paragraph B. To use the internal numbering, it's page 1 of 16. And it says the DHC series 300A models 311, 314, and 315 main landing gear have a needle roller which does not let the upper bearing turn. So that's the problem. They're identifying to the operator what the problem is that they've found in operational experiences. And then when you go through the document, you see that they're instructing the operator on what corrective action needs to be taken. And that corrective action is generally referred to as the service action, which is another term that we saw in the operating order. That is, some service action is required. So in this particular instance, the service action that was instructed was to take the pin out. And there's detailed information on how to go about that process and what needs to be done to avoid having the problem of excessive wear to the cylinder bore, which was encountered in operational experiences. And I think I should point out, my lords, that in the context of the papers before the court, and before the lower court, this is the only service bulletin that you see issued by Messier Dowty.
Issued by?
By the respondent.
Yes, thank you.
Everything else was issued by Bombardier, the aircraft manufacturer. And this has no bearing to the problem that was encountered, and it had no bearing to the subject component.
Very well, thank you.
Now, Mr. Fisher was questioned about the failure to issue a service bulletin, and I think it's useful to go to those exchanges. Page 911 in the electronic.
That's 877.
Yes.
Yes?
Yes.
Sorry, bundle
5.
53, 877.
Thank you.
No, 54, I beg your pardon.
So it starts at the bottom of page 911, 877, line 28. And what's happening now is I'm questioning him about this failure to issue the service bulletin as indicated both by the report and by the engineering order. And I say, now I see you reference a service bulletin. At any point post-1998, that is post these 3 incidences, was there a service bulletin issued which addressed the damage to the upper bearing, specifically the deformation, the breaking off of the lugs, and the fragmentation of the damper ring? Mr. Fisher answered, not to the best of my knowledge. So the learned Chief Justice then steps in, and he says, why? Given that this has happened, and given your changes that you did as a result of it, and the parts were available from 1998, why did you not suggest to operators, to users, that in the next service, they should replace those old parts with the new parts that were now available in 1998? Mr. Fisher says, the new parts will be installed during the next restoration. The court says, yes, I know, but that was for the particular airplane. What I want to know is, why, given what has happened to Air Ontario in the other 2 instances, why did you not, after 1998, give a directive to persons who had these planes that at the next available opportunity, even if it was not to be done immediately, at the next available opportunity, they should replace those old parts with the new design parts? Why didn't you do that in 1998, 1999, given that you had these instances? And given as a result of those instances, those changes you made in your production, and I say, and significant changes. The court says, why didn't you, in 1998, issue that service bulletin, or issue some recommendation? Mr. Fisher says, I don't have a response. And Lord, that sentiment of not knowing why was repeated by Mr. Fisher a number of times. The next time you see it would be at page 914.
Yes.
880 in the paper bundle, line 17. Now, what's happening here, the service bulletin, my lords, that we just looked at, that relates to the needle roller issue, I had shown that to Mr. Fisher as a further part of this line of questioning. And then I said to him, and this is the service bulletin that you issued in July 2001 to address the problem that you encountered with the needle roller and the upper bearing, correct? He says, correct. This is not relevant to Ontario. I say, I accept that. It is not relevant to this part. I'm making a different point. The court steps in. The question, why wasn't a similar service bulletin related to the Dash 8 in similar fashion? That is what she is asking after the Ontario incident, after the incident in 1996, was it? I said, yes, 96. The court says, that is the question. I say, yes, and I think, in fairness to him, he says he doesn't know, and he didn't answer. And then again at 9:15, which would be 881 in the paper bundle. Line 19. Again, I'm showing him the inapplicable service bulletin, and I'm questioning him about it quite extensively. I said, just so that there's no doubt as to the purpose of such a service bulletin, I said, so this is a tool that is open to you where you found such damage in real cases to either tell your operators to discontinue using a part, or if you're not going to so far as to discontinue using it, to tell them, look, you have some potential problems here. Go and take a look and make sure you're okay, correct? And he agreed, correct. Now, you would note, my lords, that I was asking Mr. Fisher specifically about a service bulletin, and he confirmed that no such service bulletin had been issued. But I then later on also questioned him about, whether any other type of notification, it might not have been a formal service bulletin, some other notification to indicate that there had been a problem with the parts. And that page, let's see. Hesitating, my lords, because I think it's important for me to also make the point that Mr. Fisher also confirmed that in addition to the failure to issue a service bulletin, he also confirmed that the old parts and the new parts still appeared in the operator manual. The old parts and the new parts were still shown in the operator's manual without a requirement for them to be changed. And his response to my question as to why that was happening was because they knew, that means the respondent knew, that there were operators who still had the old parts. So they continued to list them in the manuals as continuing to be usable, even though they were no longer being produced, and even though they had encountered these problems and had not issued a service bulletin. So that is also reflected in those pages. He also confirmed in those pages, that is from 9:16 going on, that, jumping in the interest of time, that there had been no retrofit, even though retrofit had been required. That's at page 9:16.
And yes, that I've got at 883,
Pardon me?
I think. Might be, yes, 883,
Yes.
line 5. And is retrofit in effect recall?
Yes, and he agreed that it is.
It's their word for recall?
Yes,
Okay.
it is. And he finishes that point.
Because we saw a tick in the box for retrofit in the works documents.
Correct.
Yeah.
And because of that, I sought to solicit from him the meaning of retrofit and whether it was something that they did.
Got it.
He confirmed that it is something that they did, and he then confirmed at the top of 9:17 that it did not occur as it related to these parts, despite the fact that the documents required there to be retrofit. It's at lines 9 through 10 where he says that is no, it did not occur.
Yes?
Yes. And it is at 9:18 where he confirms that the documents continue to remain in the manual, the old parts continue to be produced in the manual, notwithstanding that there had been no service bulletin. And so, my lords, that is the evidence that we say demonstrates not only the inadequacy and the pleaded defect, as it were, of the tendency for this damage to the upper bearing to ultimately lead to dislodgement and fragmentation of the dampering. That is also the evidence of the respondent's knowledge of it. And that is also the evidence of the respondent's failure to take any step whatsoever to notify the operator, specifically the appellant, as to the issues that they're having, the issues that they were having with the part. Having acknowledged that it is a problem that led to the change and the redesign, despite what had been previously stated in his witness statement. We therefore say, my lord, that for the Court of Appeal to have held that the learned Chief Justice's finding of there being an inadequacy as being unsupported by the evidence and as being unreasonable in the circumstances of the evidence that I've outlined and in circumstances of the totality of the evidence, inclusive not only of expert evidence, but also significant concessions from the respondent's witness, we say is a gross error, respectfully. We say it was certainly open to the learned Chief Justice in those circumstances to have found, as he did find, that there was an inadequacy, and that it is this inadequacy which resulted in the ultimate collapse of the landing gear. Now, my lord, we say that not only was there no sufficient basis for the setting aside of the learned Chief Justice's factual findings, we also say that the Court of Appeal also erred because, contrary to their role as an appellate court, the court embarked on its own analysis and expression of opinions and views on the evidence. And we feel, my lord, that the most glaring example of that would be at paragraph 27 of the judgment. Now, the judgment starts at page 144 of the electronic bundle, and it is in volume 1, tab 14 of the paper bundle. And in terms of internal numbering, we're going to paragraph 27, page 21. So now what is happening now, my lord, is that the Court of Appeal is making reference to some of the evidence that I showed his lordship to, the specific responses of Mr. Fisher to questions that had been put to him by myself. So at paragraph 27, it says, "It is readily accepted that there was a change in design in 1998, but does that translate into a flaw in the old design? In cross-examination, Mr. Fisher was asked, I am dealing specifically now with the reason for the modification. And my suggestion to you now is, having encountered specifically the Ontario scenario and recognizing that even with the sufficient hydraulic fluid, you were getting an overextension situation as a result of the damage to the upper bearing and the dampering. You modified those parts with a view to providing better support for that dampering. Is that correct? Correct. They set out the entire exchange. The Chief Justice then sought further clarification, and they then set out the entire exchange between Mr. Fisher and the court. The court said the reason you had to improve on it was you found as a result of those instances that there was a problem, that it didn't do what you wanted it to do. I mean, that's what I read from the Ontario report. As a result of that, these were the production changes that you undertook as a result of what you found. Mr. Fisher said, yes, my lord. So now here is where we say the Court of Appeal erred. We opine that the appellant merely sought to improve on an already solid design. Expending the effort to make your product better does not mean that the original is bad. An example of that fallacy in thinking is the introduction of a new Coca-Cola recipe. The resulting negative backlash to the new product led to the reintroduction of classic Coke, the original formula, which consumers seemed to think was better than the improved recipe. We agree with the appellant's assertion that the defectiveness of the old damper ring ought not to be determined by the improved robustness of the new design. Our view would be quite different had there been evidence of numerous failures in the damper rings due to poor manufacturing process or design. However, such failures as they may have been were not said to have been due to either cause directly. The incidents mentioned during the trial, save for the Air Ontario incident, were all said to be caused by poor maintenance, which led to failure of the components. And ultimately, my lord, you see over on the next page, at the top of page 23, the court then saying, in the premises, we are unable to agree with the finding of the Chief Justice that the old design was inadequate. What we say in respect of this section, my lord, the reason why I took the court to those portions of the cross-examination of Mr. Fisher is because those were significant concessions made by Mr. Fisher as it relates to the inadequacy and as to their knowledge of the inadequacy. The Court of Appeal then referenced those excerpts, and we say, respectfully, wrongly so, provided their own opinion as to how that evidence ought to be viewed or how that evidence ought to be treated. What we say is glaringly obvious, my lord, as they state their own opinion. Not once do they pose the required question whether or not, in light of that exchange, in light of what Mr. Fisher had said, it was permissible for the learned Chief Justice to have found as he did. They never posed that question. And we say that is an error, a grave error.
Yes.
And we say,
So what did they say about the absence of a service bulletin?
well, ultimately said that they actually made a determination that, in their view, no service bulletin was required.
Let's just look at that, can we, briefly?
Sure. If we start at paragraph 48, that's at the bottom of page 28 on to page 29. And it is the last sentence of paragraph 48, where they say, there was therefore no requirement for the appellant to specifically send out notices or bulletins to individual operators, specifically relating to the damper rings breaking apart.
Thank you, but had they noticed what the engineering orders said about that?
It's not apparent that they did.
Well, this conclusion seems to be linked to and to follow from the proposition that the plaintiffs are, after all, in the business and could be expected to learn of whatever went on. There wasn't any need for it is said, for the defendants to send out a bulletin.
Well, my lords, I think it goes a bit farther than that. If we go back to paragraph 39, what is happening in the preceding paragraphs of that conclusion is the court setting out various bulletins, which we say, erroneously assert, provided some notification to the appellant as to the specific problem of which we complained.
Yeah.
I think the most egregious of it would be the reference to Service Bulletin 832-144. Again, it is a service bulletin which relates specifically, it might be helpful at this point to go to it. It would be found at page 346 of the electronic bundle. It's going to be in volume 3. And I will give you the tab.
Is it tab 40?
It is. Now, you will recall, my lords, that I had taken you to Messier Dowty's Service Bulletin 83282. This Bombardier Service Bulletin 832144 is merely the aircraft's version of the same service bulletin that had previously been issued by the respondent on the same issue.
Is this the anti-rotation pin again?
Correct.
It
Yes,
is.
it is.
Oh, right.
It
Yes,
is.
it is needle roller. I see.
Needle roller, yes. Again, those terms are used interchangeably,
Yeah.
needle roller or anti-rotational pin. And again, it had absolutely no bearing to the subject part. If you were to look at page 346, electronic record 32, the paper bundle.
I'm sorry, the paper bundle 342?
Well, let me use it, may I use the internal numbering? It's page 1 of 16 of the document itself.
We're still in the same document?
Yes.
Yes?
And again, you see that the reason
I'm
is the
sorry, we're
same.
going to which page? I'm very sorry. We're going to which page?
In the electronic or the hard copy?
In the hard copy.
Okay, the hard copy is going to be
I don't think I'm in the same document because mine's got 22 pages.
Yeah.
Yes, so's mine.
And you said 1 of 16.
Which is the electronic number, please?
the electronic number is 346.
346, and then in that case it's, I think, 322 or 321. 321, I think.
Thank you.
It looks like 321. Yes. So 346, again, the reason at paragraph B, the same. The fact that they found this difficulty in models 311,
Yep.
314, 315, and of course,
Yeah.
our model is 301.
Yes?
This is
Now
all
that
to do
I'm
with
in
But
this-
what about the paragraph quoted in paragraph 37 of the Court of Appeal's judgment, which is saying, now look, within this, actually, there was one relevant paragraph, and it was sent to Bahamasair.
And it would have been sent to Bahamasair in relation to the 311s.
Yeah, but
I think if we go to page 352, electric, and internal numbering 13 of 22, you see the actual paragraph that the Court of Appeal is referring to. It's paragraph 6. Are you with me?
Yes, examine the two halves of the upper bearing. Is that the paragraph?
Correct.
Yeah.
So now, I'm going to ask you to backtrack, because that's paragraph 6. So if we go back to paragraph 1,
No, that's not
That's
the bit
not
I'm
the-
looking at.
that's not the bit that the Court of Appeal quoted in 37.
No.
37 is quoting from 518.
From where?
That's a different issue. And I'll go to that once.
Yes.
Right.
Yes, you're quite right.
Yes,
Okay, forgive me.
yes. But what is happening in paragraphs 39 to 42? The Court of Appeal is saying a number of things. They're saying, look, this service bulletin 8428144 provided some notification to the appellants as to the issue that we complained about. And number one, this service bulletin has absolutely no bearing. And not only does it have no bearing, my lords, it was agreed, and it was the evidence of both the appellants and the respondents in the court below that this had no bearing to the subject parts.
Is it the same plane or not?
It's
Same
not.
same model of plane?
It's not.
It isn't, is it?
It isn't,
No.
no. And that's why I took you to the reasons first. It's 311s, 314s, and 315s. Ours is 301.
Quite.
But the reason why I was taking you subparagraph 6 is what the court is referring to in the judgment, between
Yes.
paragraphs 39 and 42.
Thank you.
Now, that subparagraph is a part of the process of taking out the pin. And the reason why you have this paragraph 6 and the requirement to measure the upper bearing is because they found, as is indicated on the first page, that the pin was not only causing wear to the cylinder bore, it was also causing wear to the upper bearing. And so therefore you must measure the upper bearing as you're taking it and taking the pin out to make sure that there's no wear. And if there is wear, then you install the part. So the point then is that the Court of Appeal is not only referring to the wrong document as being applicable and as providing some type of warning to the appellant, but it is an entire process that has absolutely nothing to do with the subject aircraft. So if we can deal with 518 now. 518 is at page 362 of the electronic.
Tab 41.
Yes. And again, to put this in its background, in its proper context, it is again issued in relation to the same anti-rotational pin needle roller problem.
And the passage is on the following page, isn't it?
Yes. Yes. And I think it's important to make the point that at page 2, they identify the problem again, that being the excessive bore to the cylinder bore caused by this pin. And then when you get to the top of the page, they say, to address this issue, that is, to address the specific issue caused by the presence of this pin, these are the things that you should do. And it is that third paragraph that the Court of Appeal recite in paragraph 37. Maudslum is issued to introduce an improved upper bearing, a new dampering. This Maudslum may be incorporated as a product improvement during the overhaul at operator request. Production cut-in is at aircraft serial number 534. So to put that in its context, my lords, 518 is saying, look, in these 311s, these 314s, these 315s that have this upper bearing with the anti-rotational pin, there is available a new upper bearing that you have the option of installing at your convenience. And assistance would be given to you in that process. Again, it does not speak at all to the 301s. And I think it is important to make the point from an industry standpoint. It's not appropriate to take guidance from a service bulletin or an all operators message. That's not applicable to the aircraft. I mean, that would give rise, I would say, to all manner of other liability. So those, my lord, we say are...
Well, the point the Court of Appeal is making, whether it's any good or not, is something we'll have to think about. But what they're saying is, this went to everybody who had 311s. You had 311s. It tells you that, among other things, that there is a modification which would also apply to 301s. That's what they're saying, isn't it?
That is what they're saying.
Yeah.
But there are a number of problems with that suggestion. In both contexts. That is, in relation to 518 and also in relation to 832.144.
Yeah.
In each case where there is a reference to the availability of this new part, this reference is made in the context of replacing the upper bearing by reason of the fact that it is worn due to the presence of this pin. So if you have an upper bearing in the 301 that has no pin, there is no reason for you to suspect that this is something applicable to you.
So
And
you
I think,
say no need, you can't read into this anything which Bahamasair ought to have said, oh Lord, what about the 301s?
absolutely not.
Yes,
and in fact, my lord, what I would add to that is, at no point in the court below did the respondent suggest that there was such an obligation. You had witnesses in the box. You had the director of maintenance in the person of Tracy Cooper. You had Mr. Moss, who actually did the work, extensively cross-examined. And at no point was it suggested to either of these men that, look, there's AOM 518, and there's Service Bulletin 832.144 that required you to do certain things. Now, had that proposition of fact been put to them, then perhaps they would have had a very good answer for it, an answer that's entirely consistent with the submission that I'm now making. But we say it is not open to the Court of Appeal to draw that inference without there having been that suggestion by way of contrary proposition, and certainly not in light of what the evidence was. It was agreed consistently that these bulletins had nothing to do with the subject aircraft. Not only did Mr. Fisher say it in his witness statement, he said it repeatedly on cross-examination. No, this is not applicable, not applicable. So the Court of Appeal, we say, cannot make it applicable. Now, given that we're on that point, that is one of the points we say that, you know, even once you recognize that it was not proper for the court to have intervened and set aside the factual findings of the judge, you then have the other problem. That problem being the judgment that they replaced the learned Chief Justice's judgment with is marred with error. And that is but only two of the errors. And I think it's useful to now go to one of the fundamental errors which served the purpose, they say, for their intervention in the first place. So if we go to, this is part 16 of the written case. 15.
This is part 15 of your case.
Yes.
Thank you.
And it is referencing a portion of the judgment, paragraph 19 of the Court of Appeal judgment. Again, the Court of Appeal judgment is volume 1, tab 14. In the electronic record, it is page 144.
Yes.
Starting at page 19.
I'm sorry, if we start at
Starting at paragraph 19, sorry.
the Court of Appeal.
Court of Appeal judgment,
Thank you.
page 145. They are describing the basis for their contention that the learned Chief Justice did not take full advantage or proper advantage of having seen and heard the witnesses in the court below. And we say their very basis for making that suggestion or arriving at that conclusion is an error, a misunderstanding of the evidence as it was in the court below. The nature of the misunderstanding, we say, there was ultimately an airworthiness directive that was issued in June of 2006. That was issued by the regulatory body. Prior to the issuance of the airworthiness directive, there was this specific servicing task card known as task card 321015. And it's a relatively simple thing. It is just the process by virtue of which you service the landing gear.
So this is an internal Bahamasair service document, is it?
No, it's actually in the airport, in the aircraft maintenance manual.
Lives in the plane?
Yes. It's in the manual.
In the manual produced by the respondents.
Correct.
Got it, thank you.
Correct.
Bombardier.
Issued by
Is that
Bombardier.
tab 76, isn't it?
It is, yes.
And it's quite easy to see then.
Yes.
That's got on it a date at the bottom, November 29, 2005.
Correct.
Is that the issue date?
That is the issue date. It's actually, or I'd put it this way, that is the date of the issue of that particular volume of the maintenance manual.
Okay.
But in any event, it is prior to June of 2006 when the airworthiness directive was issued. So the court, when you read through these paragraphs, 20 through 22, the court is, we say, erroneously of the view that Mr. Morse, when he spoke about carrying out the service of the aircraft, the landing gear, pursuant to 321015, was making a reference to the airworthiness directive, which was not yet in operation, had not yet been issued, when in fact he was merely referring to that component of the airworthiness directive, whereby the servicing pursuant to 32.10.15 was made mandatory. And you were required to comply with it so long as you had not previously done so. But the evidence was that Bahamasair had previously done so. They had done so on the 19th of May, 2006, prior to the issuance of the AD. The court was of the view that the state of the evidence was somewhat of an inconsistency in that the learned Chief Justice had accepted the evidence of Mr. Morse, which the Court of Appeal is saying was that he had complied with an AD which had not yet been issued. Where we say, looking at all of the supporting documents demonstrate, and the evidence, demonstrates, one, that the task card existed prior to the AD, and secondly, that all the AD did was incorporate the task card, making that servicing requirement mandatory. And again, to give this a little history, you see in the papers that there are a number of other instances of landing gear collapse, 2004, 2005, and the operative cause was identified as being improper servicing. And it is for this reason that the task card was implemented to make servicing a priority, proper servicing a priority.
So was there an issue as to whether there was a task card prior to the servicing in May 06?
That there was never such an issue, no.
There wasn't?
No. It was merely a misunderstanding on the part of the Court of Appeal. It was generally accepted that there was a task card in operation, and it had been, at least from 2005.
Doesn't that have to follow from the terms of the Airworthiness Directive?
Well, it does.
Because they're saying incorporate this unless already
accomplished.
Yeah.
It does.
This, the actual document's at 44, isn't it, tab 44?
Yes, that is the AD. And that is exactly correct, my lady. All the AD is saying that, look, we find that we're having a number of collapses by reason of improper servicing. There is a task card that has been issued that you're required to comply with every 7,000 cycles. The regulatory body now makes it mandatory.
Yeah. Now, the task card, if I've got it right, is volume 7, tab 76,
Yes.
page 1327, by the look of it.
That is correct.
So that's the one, is it?
That is it. And if you look at the bottom,
The November date on it.
November date.
And I think the point that's being made somewhere, the point is referred to both by the judge and by the Court of Appeal, is that it ought to have been filled out in the box towards the top of the front page with what had been done by whom and when.
Correct.
And nobody had filled it in.
Well, they say they're looking at this particular document, which is a specimen document from the manual itself.
Oh, this is just a specimen?
Yes, it's a part of the manual. And this is what was attached to Mr. Morse's witness statement. That, in conjunction with the pages from the manual itself.
Yeah. But was it a legitimate criticism that whatever task card had been, not just a specimen, but the task card on the 19th of May 2006 hadn't been filled in?
Well,
doesn't the judge say that somewhere?
Well, I'll say this. It is not a legitimate complaint, given that it was agreed that the task card was complied with. It was accepted by all witnesses, including Mr. Fisher, that the landing gear was serviced on the 19th of May, 2006. He says that in his witness statement.
Yes, I've got that. But there was a task card which hadn't been filled in when it should have been, even though the work had been done.
Well, there was no specific task card.
No card,
right.
I see. Right.
The evidence from the appellant as to the compliance with the task card was in the form of the witness statements, where the mechanic said that it had been done, and the continuation sheet, where at item 24, it indicated that the task card, the servicing had been done. And of course, Fisher's statement also, that the servicing had been done at the time of the cylinder repair.
Yeah.
But the point here, though, my lord, is that when you look at the transcript, initially, you do see where this is a concern that is raised by the learned Chief Justice. He did, in fact, misinterpret the evidence as saying that Mr. Morse had complied with an airworthiness directive in May of 2006 that didn't come out until June 2006. But there is a subsequent point in the transcript where he specifically requests clarification of that issue, and he got it. And I will just give you that page number.
(765), according to your case at 1515.
Yes. And it starts at 764, going over to 765.
Mrs. Roll, I know you're running out of time, so
Yes, I'm trying to.
I'll very quickly. Is this the same issue as the complaint addressed in the Court of Appeal at paragraph 14, that you never produced your maintenance control manual?
No, that's an entirely
That's a
different
different complaint.
That is,
So very briefly, what do you say about that?
well, two things. If you go ultimately to Court of Appeal judgment, paragraph 32.
22?
32.
32, yeah.
You'll recall, my lords, that when I took you to the amended defense, that was a component of their plea of contributory negligence. It was rejected on a causation basis by the learned Chief Justice. It then reappeared as a ground of appeal, and the appellate court addresses it in paragraph 32, where it says, grounds 5, 8, and 9 do not relate to the cause of the crash directly. A failure to keep records does not mean a party has not adequately maintained a piece of equipment. Further, merely because a person lacks proper qualifications, such as degrees, diplomas, or certificates, does not mean he is incapable of properly effecting repairs to or maintaining an aircraft. The evidence adduced at the trial does not support the allegation. Without more, these grounds must fail.
I'm not sure that really bites on the complaint they'd made at 14, which isn't about keeping records, it's about not producing a record.
Well, that is it was pleaded not only as a plea, but also as a ground of appeal that was rejected. There is a significant amount of evidence that did not arise so much in the Court of Appeal, but Mr. Hall, for example, gave evidence of the fact that it is consistent in the aviation industry to discard components of manual of that sort that are no longer relevant, having been revised, and that was his evidence.
Very well, thank you.
In any event, we say, my lord, that it was something that the court rejected, and to the extent that it is something that is to now be raised, it would have to be raised, we say, by cross-appeal, given that the Court of Appeal dismissed it as being a ground on which they rely.
Well, I'm not sure that's right in view of the Privy Council rules, but you'd better proceed and indeed conclude.
Yes. And so, my lord, we say that in addition to that error, that is the error as to the relationship between the task card and the airworthiness directive, I've already outlined the errors as to AOM 518 and 832.144. Where I will conclude, my lord, is here, part 17 of my written case. If you go again to the Court of Appeals judgment, paragraph 15, somewhat ending, my lords, where I started. In paragraph 15, my lords, you see that the court is summarizing, before it gets into the meat of its judgment, what is agreed and what is disputed. And at the final sentence of that paragraph, you see that the court says, what is disputed is the cause of the collapse of the left main landing gear, to wit, whether it was due to a defective dampering or an absent dampering or poor maintenance or a combination of those factors. Now, one of the reasons why we also say, quite apart from the fact that it's marred by error, we say, one of the problems also with the Court of Appeal's judgment is that having regard to what was specifically appealed and what was not appealed, that is, the finding that the dampering was installed, that it fragmented, and that that was the cause for the collapse was not appealed. All of the findings of negligent maintenance, improper servicing, that formed the defendant's case of negligent maintenance was rejected by the court below and not appealed. So if you have a circumstance where, by virtue of the Court of Appeal judgment, the learned Chief Justice's entire ruling is set aside, in the context of what now exists, there is no determination as to the cause of the collapse of the landing gear, because none of the operative causes or the pleas that led to the operative causes were appealed. And the findings that the learned Chief Justice made that gave us the answer to the litigation have been set aside. So here we are with a judgment that leaves open the very question, the core of the litigation, that being what caused the landing gear to collapse. And we say that that is the most unsatisfactory result.
Well, that can frequently arise where the plaintiff has failed to discharge the burden of proof cast on it. It doesn't mean the absence of a concrete finding as to what the cause of the accident isn't uncommon.
Well, we say that given that both in the court below as well as the Court of Appeal themselves acknowledge that is the purpose of the litigation.
No, it's not. It's not the purpose of the litigant.
Well, I probably take it a bit higher than I ought by saying its purpose, but certainly it is a core issue to be determined.
Well,
The fact that there has been an event and the fact that we agree that this event can only happen by a number of the presence of 4 factors, and the litigation in its present stance and with the present ruling does not make a determination as to which of those factors resulted in
Yes, but if the court
collapse.
is not brought to the point of conviction on the balance of probabilities as to what the cause is, then its duty is not to speculate as to the reason that the accident occurred. On the contrary, its duty is to say that the plaintiff has not discharged the onus of proof.
Well, my Lord, we say that the learned Chief Justice in his determination, both as to the cause of the collapse, that being the inadequacy and the ultimate fragmentation, is an indication of the plaintiff proving what they pleaded.
Yeah, okay.
So if you've proven what you've pleaded, you've discharged the burden that was on you.
yes.
Because we say
He said you had.
Yes.
We're only taking issue with your additional proposition that the Court of Appeal can't be right because they haven't provided an answer to the question what caused the collapse. You don't need to do that if it be true, if it be correct, if it be correct that you haven't proved that they did anything wrong.
Well, to use his lordship's verbiage, if we're not correct, it is, we say, an undesirable resolution of litigation.
It's not a public inquiry, Mrs.
But of
Roll.
course we say.
It's an action for compensation.
Well, I
Anyway,
think
there we are. It's enough said.
I think, my Lord, what brings in the public policy element is the fact that it is an aviation industry issue, and it is a public issue by virtue of who the plaintiff and the appellant are. So it's desirable to have that issue determined for various reasons. That may not necessarily be judicial. And that's why it's phrased in the context of desirability and suitability.
Right.
But in any event, my Lord, we do say that having regard to the standard that was placed upon the appellant, that the duty was discharged. The final issue, my Lord, is that of quantum.
Thank you very much. I'm afraid you've finished your available time, Mrs. Rowell.
Yes, my Lord, it wasn't anything that I'd intended to elaborate
Good.
significantly.
Thank you very much indeed.
I'm obliged.
Mr. Rowell? Right. Right, Mr. Marland.
Just on that last point, of course, I would observe that completely ignores the existence of the flight safety inspector investigation, which was, if you like, the closest equivalent one gets to an inquiry in this matter. Before I begin, in light of my Lord Wilson's observations about cross-appeal, do I need to address you briefly on the cross-appeal point that's raised, or should I just crack on with it?
Well, it's a matter for you.
I can take it quite shortly.
I mean, my observation was born of reading our rules today and seeing that where an appellant wanted to support a judgment on grounds other than those adopted in the court below, he didn't have to cross-appeal, but did have to make that point clear in his case.
Absolutely what we've done in my submission. That's Rule 25, of course.
Yes.
And we say that here, of course, the first flaw in the submission of my learned friend is that there's no order from the Court of Appeal. And, of course, you cross-appeal orders, not judgments. If there were such an order, it would be what the Court of Appeal say at paragraph 69 of their judgment, and it's tab 14. Hopefully my learned friend Mr. Oconee will sing out electronic references because I don't have them.
Well, you should have them.
I should have them, but if I could just explain, between the filing of my written statement, which you may recall adverted to problems with the electronic bundle, and today, the electronic numbering has been through no less than 5 reiterations.
Well, that should not have taken place.
I agree entirely, my lord. And insofar as it's any fault of ours, we apologise. So paragraph 69, which is at page 179 of the electronic, tab 14, 162, just the concluding paragraph, we allow the appeal with cost to the appellant both here and in the court below, such cost to be taxed if not agreed. That, we say, is the equivalent of the order, and we don't seek to vary that. So,
Quite.
So that's the short point. The subsequent point, even if we're wrong on that, is recently confirmed by the board in December in a case that was before them then called Starray, which I have, we don't need to go to it. The board, of course, has a discretion to allow cross-appeals out of time. Here, the position has been known from our notice for over a year. No point was taken when we filed our notice of objection, making it clear that we were relying on these additional grounds. The first wind, unlike in the Starray case, that there was going to be some sort of technical spat about this was when we received the written case. In the circumstances, even if it's right that we needed to make this by way of a cross-appeal, the board should give leave. So that deals with that, hopefully briefly. Start quickly with some hopefully uncontroversial landscape going into this claim. The first is that, of course, commercial aviation is heavily regulated. Manufacture of aviation components is heavily regulated. Maintenance is heavily regulated. For what it's worth, so is piloting. In this case, as you've heard, Transport Canada, so governmental body, fulfilled the role of the design authority for the landing gear and its components, and also by happy circumstance, because of Bombardier being the aircraft type manufacturer, with the design authority and type authority for the aircraft as a whole. This means that, amongst other things, they have to sign off approval for these parts before they're put into circulation. Before they can be used on these aircraft, so these are the original parts, Transport Canada, as a governmental body charged with aviation safety, has to sign off on them. Now, where that leads us to, again, this is in terms of initial landscape, is a statement of Mr. Justice Tomlinson's, as he was, in a case called Lamson and Embraer, which involved a crash in this country. That is in Authorities Bundle 2, tab 15, which electronically is, I understand, is the same. Happy coincidence. Now, this, very briefly, this was a case that involved the crash of an Embraer Banderanti after takeoff from Leeds Bradford. And one of the issues in that case was that the artificial horizons didn't work. Those were manufactured by the defendant. But all I really want to go to in this case is paragraph 17, which should be at page 2370. For what is, Mr. Justice Tomlinson observes, an uncontroversial proposition, and I hope it is. It says this: the claimants referred me to several authorities in which there's to be found discussion of the role and purpose of certification. And
I'm sorry, 2370, did you say?
Yes, 2370. It should be paragraph 17 of the judgment.
Yes, I'm afraid it's not on the electronic bundle. This is a judgment of Sir Michael Ogden.
Right. Quantum.
What's the name of the case again, please?
It's Lamson and Embraer.
Lamson, AVA.
It should be tab 15.
Yes, well, proceed in the meantime, please.
Well, if I read it out, perhaps.
It's actually tab 113.
So, yes, tab 15 says page, well, in the hard copy,
Tab 113.
Tab 130, I'm grateful, my lord.
Yes?
So, the claimants refer me to several authorities in which there's to be found discussion of the role and purpose of certification and its relevance where the inquiry is whether manufacturers, or for that matter, pilots, and I would add there in parentheses, and maintainers, have fallen short of the standards imposed by the common law duty of care. I do not need to burden this judgment with citation from those authorities. The principle are, it seems to me, clear and uncontroversial. Compliance with certification requirements is no answer to a claim in negligence. Nonetheless, certification requirements are proper to be taken into account in an overall evaluation of what reasonably is required. The more heavily regulated the activity, the more persuasive that evidence might be. The flying of aircraft, particularly those carrying fare-paying passengers, must inevitably rate as one of the more heavily regulated activities. The nature of the regulatory requirements should therefore carry considerable but not decisive weight in the evaluation of what reasonably is required of those engaged in the industry. Now, by extension in my submission, although compliance with certification requirements is not dispositive of a claim in negligence, non-compliance is at the very least persuasive, almost compelling evidence that there is negligence or that there is a failure to exercise reasonable care, if I can put it that way. The relevance of oversight, in particular the Transport Canada oversight in this case, is, as Mr. Justice Tomlinson rightly, of course, observes, it does not oust the function of the court, but it is important to take the regulatory landscape and indeed the actions of regulators and compliance with regulations into account. Now, that's important in this case in two respects. Firstly, as regards Messier Dowty, the allegation is, of course, of a design defect. In that context, and we'll go into this in more detail, it's important to have in mind, and I put it no higher than that Transport Canada were aware of the previous incidents. Transport Canada did not, contrary to the way it's sometimes put by the claimant, mandate any change to the new design, but were, as the safety regulator, content with a phase-out. Critically, I say, even after this incident and even after the investigation into this incident, there was no change to Transport Canada's stance as safety regulator. The second respect in which the regulatory regime and certification background is relevant in this case, I say, is that as regards Bahamasair, as indeed the judge at first instance found and the Court of Appeal found, as I will take you to in due course, there were multiple examples of breach of applicable maintenance regulations. Critically, I say that's not shown just by the Flight Safety Inspectorate report. It comes out of the mouths of their own witnesses. And I'll explore that in more detail in due course. And again, as a headline point that I want to make, it's important to clear the ground in respect of what I say is a fatal flaw in the claimant's case, which appears to have infected the first instance judgment, and that is the sequence of events. Essentially, the claimant confuses and continues to confuse cause and effect. In all of the previous incidents, apparently, save for this one, if Bahamasair are right, fragmentation of the damper ring is an effect of loss of damping from some other initiating cause. It is not, categorically not, the root cause. Now, you were taken by my learned friend to paragraph 19 in the Statement of Facts and Issues, which should be in volume 9. In the electronic, it's tab 92, hopefully 1858, and in the hard copy, 1808.
Yes?
What you were taken to the 4 potential, possible causes. The important bit for these purposes is the rider at the bottom of paragraph 19, which was not read out. These causes are not mutually exclusive. If you have loss of damping caused by insufficient hydraulic fluid, that, and I'm going to explain how, leads to fragmentation of the damper ring. It leads to damage to these parts. Perhaps the best place to see this is if we take up the airworthiness directive produced by Transport Canada, which is in volume 3, tab 44, in the hard copy 344, electronic 369.
This is the AD of...
This is the AD that was promulgated in June. And what it says this, if you see there's a section there called background. And this explains what's led to the AD. Over the past 10 years, there have been 6 cases reported in which the main landing gear shock strut piston has overextended, allowing the torque links to go over centre and rest on the piston. This resulted in loss of shock absorption on touchdown, and in one case resulted in the failure of a shock strut cylinder housing. Although it has not occurred in any of the reported cases, failure of the shock strut cylinder housing could also possibly result in a subsequent loss of directional control. And then this, investigation has determined that overextension of the shock strut resulted from damage to the upper bearing and seal carrier caused by a loss of internal damping. This is important, and sorry, whilst we're there, if you turn back one tab to tab 43, which is, I do apologise, 2 tabs, to tab 42, which is an all operators memo from Bombardier that I believe you were conspicuously not taken to. It's page 340, hard copy, 365 electronic. This is an all operators message put out by Bombardier, and it's put out in 2005. So it predates the overhaul, servicing, what have you, by Mr. Moss. And you will see the same discussion. 6 incidents have been reported, etc. Investigation has determined that overextension of the shock strut results from damage to the upper bearing and seal carrier caused by a loss of internal damping. 2 causes have been established for the loss of damping. And then this, in answer to the point that's made by the claimant about no prior, if you like, information applicable to this aircraft type. The 2 bullet points over the page, the first one we don't need to concern ourselves with because that is the anti-rotation pin. However, the second bullet point is applicable to this aircraft. For Series 100, 200 and 300 aircraft, all models, fluid can seep past the seals as the piston extends during normal gear cycling and can result in significant loss of hydraulic fluid over time. This seepage is normal and is not readily visible. If left uncorrected, insufficient hydraulic fluid will be available to provide flow through the damping orifices. It should be noted that improper servicing of the shock strut may contribute to this problem. Operators should ensure that shock struts are always properly serviced. If nitrogen is added to the strut, a complete servicing, including a check of the strut hydraulic fluid level, should be accomplished within 50 flight hours. So again, damage to the upper bearing and seal carrier is an effect, not a cause. The causes are identified there, and of those applicable to this model of aircraft, the only cause identified, and I'm going to show you why that was the only cause that could be identified from the previous incidents applicable to this model, was insufficient hydraulic fluid. Now, that's important in this case because the claimant's case is that the parts are not robust enough to withstand normal usage. Operating where damping has been lost through some other initiating cause is not, in my submission, normal usage. Fragmentation of these parts occurs because the initiating loss of damping allows a hammering interaction between the upper bearing and the seal carrier. Normal use, one can see from a document which is in Bundle 8, tab 81, starting at page 1428 hard copy, which is 1474 electronic, you'll see there a short document entitled Shock Strut Outstroke Damping. Now, I'm afraid the pictures in this, having been through the reprographic mill a number of times, are not entirely helpful. But if you could turn, please, to page 1433 and 1434.
Can you give me the bundle number again?
It's tab 81 in Bundle 8.
Thank you.
My lady.
And whose document is it?
I believe this was produced by us, the respondent.
Yeah, but where's it come from?
It comes from, if I recall correctly, I'm sure I'll be corrected by those who were there, it was produced in order to try and explain the process and to illustrate graphically the process of how damping works.
So something done for the purposes of the action?
Yes.
I see.
As I understand it.
Okay.
Yes, yes. So on page 1433, which is 1479 electronically, you'll see that what's said there is after the landing loads, this is the dialogue below the picture, I should say. After the landing loads have been absorbed, the nitrogen expands, causing the shock strut to extend. The piston is pushed back down the cylinder, which reduces the volume behind the upper bearing. The upper bearing now drags the rebound ring in the opposite direction. Flow of the displaced fluid out of the rebound chamber is now limited by the orifice holes. Those are the metering holes that my learned friend referred to earlier. This slows the velocity of the piston, which ensures the upper bearing makes gentle, non-catastrophic contact with the seal carrier. Then over the page, if there is no damping, there is no control over the impact velocity of the upper bearing with the seal carrier. Material damage will occur. So, in my submission, this is one of the problems that the claimant never grapples with, that in normal usage, the contact is gentle and non-catastrophic. The hammering interaction, which is what has led to all of the previous incidents, doesn't occur in normal usage. Now, one can see this in the evidence of the witnesses as well, and that, in my submission, is the witnesses of both sides. Mr. Fisher, witness for the respondent, in Bundle 4, tab 47 is his witness statement.
Before you go on to that,
Yes.
is normal properly topped up with hydraulic fluid? Is that the normal we're talking about here?
Yes.
Right.
Yes.
And so how does the Ontario situation...
I'll come to that, but in essence, to foreshadow that, in terms of the previous incidences, there are two. First of all of the previous incidents have an initiating cause of loss of damping. In the needle roller and Air Ontario cases, that cause was excessive wear to the cylinder, which is absolutely not a feature of this case, and I'll take you to that. In all other cases, it's insufficient fluid. But in all cases, there is an initiating cause. The initiating cause is not damage to these components. That's an effect. So,
Well, that's the assertion. If your lugs did break, you would lose damping, wouldn't you?
you would, but what I'm saying is that none of the other previous examples, the lugs breaking is the cause of loss of damping,
Well,
it's the effect.
So you say.
Yes. Well, no, I'll take you through those and make that good.
All right.
And indeed, as I say, that's borne out by the language of the AD and the All Operators Memo.
Got that.
Yes. So, do apologise. Bundle 4, tab 47, Mr. Fisher's witness statement, at paragraphs 39 and 40. So that starts at 436 in the electronic, and the relevant paragraphs are... Oh, sorry, it's page 435 and 436 are the relevant pages in the electronic. 39 and 40, you see Mr. Fisher explaining that. When the piston extends or rebounds on the outstroke, the free flow of oil from out of the rebound chamber is restricted by changing position of the damper ring as it moves within its groove in the upper bearing. This restricts the flow back of the oil through a series of metering holes in the damper ring and slows the extension of the piston. When slowed or damped, the upper face of the seal carrier and lower face of the upper bearing come to rest softly upon the other at the full outstroke of the piston with no damage to either component. When damping is compromised, the seal carrier and upper bearing will strike one another with more force, damaging these components. The damage to these components can, over time, result in an over-centering condition. And then Mr. Moss, whose witness statement is at tab 45, says at paragraph 75 and 76, which is at page 365, 394 electronically. He says this: I've reviewed the Messier Dowty report, which for your note, we don't need to go to it, is the report at tab 15 of volume 2, which concludes that C6BFN's collapse was the result of a damaged upper bearing caused by a loss of damping of the speed of the extension of the shock strut on outstroke. The excessive speed of extension of the shock strut results in undetectable damage to the upper bearing and to the seal carrier with which it comes into contact. I agree with this conclusion of the Messier Dowty report, and I note that this sequence of events resulting in damage to the upper bearing and failure of the shock strut is entirely consistent with the report in Airworthiness Directive, which advises of, and we've seen that. This sequence, as being the sequence, and this sequence, as I'm going to say, is fatal to the claimant's theories of causation, is confirmed in cross-examination by the claimant's own expert, Mr. Hall. Mr. Hall was asked about this. That's in Bundle 5, tab 53, and it's page 826, which should be 860 if you're in the electronic.
The number again, please, for the...
Yes, it's bundle 5,
Yeah.
tab 53, it's 825 to 826. Yes, which will be 859 to 860 electronically.
This is the bundle that goes backwards, I think. Goes backwards.
The bundle goes backwards, I hope. Do you have on that page, it should be internal page 126 of the transcript.
Yes?
There's a question at the bottom, it starts at line 19, which after a false start at line 22 becomes this. Now, in your opinion, this is to the claimant's expert, Mr. Hall, can you just indicate to the court as best you can, assuming your analysis of how the failure of these things takes place, which element or which product component, which piece, whether the upper bearing or the damper ring, which piece goes first or deteriorates first? Based on the physical evidence of the parts I've reviewed and the Dowty documentation in the EOs and EI, I believe it's the bearing that fails first, provides the reduced support for the damper ring, which leads to the damper ring failing. Now, what I'm going to say, and I'm going to make this good by reference to the previous incident, there was not one piece of evidence before the court, not one, which shows fragmentation of the damper ring, or indeed damage to the upper bearing, without an initial loss of damping. The importance of this is that for the claimant's case to be good, as we'll see in due course, the initiating cause has to be the damage to these parts. And there is simply no evidence supporting that.
You say the initiating cause has to be...
Has to be the damage to the parts.
To the damper.
So there's basically no loss of damping.
Which parts?
Which parts?
The upper bearing and the damper ring.
Yes.
That, on the claimant's case, is the initiating cause, not the effect. But in all other instances, it's in fact the effect, and we'll see that. So as I said earlier, you can see from what the narrative in the all operators message that we saw and the Transport Canada document, two root causes are identified in respect of all of the other previous instances. They are either excessive wear to the cylinder or insufficient hydraulic fluid. Not only was it a factor in the needle roller, it was also a factor in Air Ontario. And we can see that in bundle 3 at page 242, which should be behind tab 27, and that is 267 electronically. In 242, you'll see there should be a section 5 that says additional data.
Sorry, bundle 3.
Bundle 3, tab 27,
Thank
my
you.
lord, and it's 242.
Thank you very much.
This is
the defendant's report.
This is, yes, this was the second report, so back in 1997, into instance. So this is the one that really focuses, if you like, on Air Ontario. I'll come in more detail to the previous instance, but essentially what you have is there's two incidents where damage is discovered on routine shop visits. One was at Piedmont Aviation. Air Ontario is the first one from memory where Messier Dowty actually get the parts themselves, so it's the one that they're looking at in detail.
Right. Well, we'll continue this fascinating exercise at 2 o'clock.
Great.